Good afternoon, ladies and gentlemen. I'm sorry. I've been having internet issues and it stopped during the previous calendar. So I had to switch channels. So let's hope this works. There we go. All right, there we are. Ladies and gentlemen, this is the 1 p.m. calendar. I'm Judge Tammy Long Hayward. This is the January 15, 2025 Civil Motions and Hearings calendar. I'm going to call the calendar and we will determine who's here and go from there. All right, the first case on the calendar is Shakia Denise Shaw, Robert Shaw, Willie Banks versus Riverwood Housing Partners and John Doe's Jeffrey Morley.
Good afternoon, Your Honor. Josh Wood for the defendant, along with Ann Rogers from Weinberg, Wheeler, Hudgens, Gun and Dial.
Okay. You said along with Ann Rogers?
Yes, Your Honor.
Okay.
And we
Jeff Morley here.
And we've also set up a court reporter, Your Honor, who I see is on from Veritext, Tabitha Richards.
All right, Ms. Richards.
Your Honor, you have Michael Smith here for the plaintiffs, along with Brian Mickelson, Daniel Beer, and Nicole Buchwald.
All righty, so this sounds like it'll take more than 5 minutes.
Might take a few.
Ladies and gentlemen, let me run through and see if there's a couple of things we can get out of the way before we give you all the time that you deserve. Latanya Denise Turner versus Brian Widener, State of Georgia, and Saleha Holdings. Ms. Powell, is that one that rescheduled?
Checking out. Judge, position 2 did reschedule. Yes, ma'am. And position 3, the motion is moot, so they're excused.
I'm sorry, Lakia Russell?
Yes, ma'am.
Okay. So anyone here with those cases are being rescheduled. Notice will be sent. So Turner versus Widener and Russell versus Kakiwat. Next case is Bilson and Associates versus Tailored Design.
Colin Mason here, Your Honor, for Bilson and Associates. This is our motion for contempt and sanctions. I don't anticipate it taking more than a few minutes for me.
Okay, is this post-judgment and they haven't responded?
Correct, Your Honor.
I'm Taylor Design. I'm with Taylor Design.
All right, can you show me your face, ma'am?
I thought I had it on here, Dora.
Okay, so Miss Dora, it works better if you can only operate from one device. Okay. They will give each other feedback if you have 2 devices too close to each other.
Okay. Let me
like that.
Okay, let me turn that other one off. Okay.
All right. So is Tailored Design is an LLC?
Yes.
So that's a corporation. Do you have an attorney to represent you in state court?
No.
Okay. So there's case law that says that if you have a corporation that you're required to have an attorney represent you in state court, because when you incorporate, even though you may be the sole owner of the company, the incorporation means that there may be other individuals who are owed a fiduciary duty, and the attorney protects those interests. So you don't have an attorney representing you?
No.
Did you have an attorney representing you in the underlying case?
The underlying case that's before me?
So the reason that you're before this court now is because there's been a judgment against you. It may have been a default judgment, meaning that you didn't respond when you were supposed to defend on paper. And because of that, okay, so you're saying that you were never served with a notice of suit in this case?
No, because the address they have on the paperwork, that's no longer the registered agent address. So I never received any of this. That address was no longer as of April.
April when, ma'am?
2024.
Okay, hold on a second. Let me get to the, my notes. Okay, so let me ask you, Miss, what's your last name?
Williams,
All right, so Miss Williams, so you operate tailored design?
yes,
Okay. And you said that the address that is on the paperwork is not the address of the registered agent.
not as of April of 2024.
Okay, I'm gonna assume this case was filed before April of 2024. Am I correct, Mr. Mason?
I believe so, Your Honor. I can double check that real quick and just confirm, but I believe that would be correct. Our default judgment was entered on June 6th of 24, and we do have, I believe, proof of personal service either on an officer of the corporation or through their registered agent.
Okay, and can you give me the service date? I'm sorry, I don't have that in my notes.
Certainly, Your Honor. Service date of the lawsuit or the motion? I'm assuming the lawsuit.
Yes.
Would you like me to screen share that with you, Your Honor?
Sure.
Got it in the file, but I want to make sure I get actual document before the court. There we are. Got two here, Your Honor. There we are. So this would have been served in February, Your Honor, I believe, and I can go ahead and share this with the court.
February of 2024?
Correct, Your Honor.
All right, and it was served on the registered agent?
It was served on, it's a sheriff's entry of service, Your Honor, served on Maurice Johnson. So
I'm
that
sorry?
would be Maurice Johnson, Your Honor, and that would be
And,
the registered agent.
okay. All right, so ma'am, the lawsuit was served in February of 2024 on Maurice Johnson. That was before the date that you alleged that the registered agent changed.
Okay, I never received it. So,
Okay, once your registered agent is served, they have a responsibility to you to give you notice of the lawsuit. Once the plaintiffs have done what they're supposed to do, which is to serve the registered agent that's noted on the Secretary of State's information, then because it's a corporation, they can serve an officer personally, but generally the registered agent is there for service. So they've done what they were supposed to do. There was
I only have in the paperwork September and October.
I'm not sure what paperwork you're talking about now.
The one that was sent to me in the mail.
Okay.
Your Honor,
They may have sent pleadings to you in the mail, but you would have received notice of the lawsuit through your registered agent.
I never received that.
Okay. All right, ladies and gentlemen, I have a lot of people who come on as iPhone. I can't help you if you don't put your first name and last name on the screen, because as I'm dealing with other cases, if there's something that I need to figure out about your case, whether it's been called previously or whether I have it as rescheduled, I don't know to give you that information as long as I don't have your information. So I have an iPhone 4. If you could change your name, you're looking for the rename function on your device for the Zoom. So please change your name, first and last name. Thank you. Now, Miss Williams, unfortunately, part of, or fortunately, part of having a business is that businesses operate in a certain way. If you have a registered agent, it's their responsibility to give you information about a lawsuit. Because you're not putting your own personal information out there, you have to rely upon them. But so does the plaintiff. So once they've served the registered agent, and as long as the things didn't change prior to their service, then service is deemed, it's deemed correct. So in this case, a judgment was a default judgment, meaning you were served with a lawsuit, you did not answer timely, so that you could defend the lawsuit. So a default judgment was given. Once the default judgment was ordered by the court, then at that point, they will pursue means to collect on the judgment. This is what's called a post-judgment contempt hearing, meaning that they've sent you information requesting information about your assets in order to collect on the judgment, and you have not responded to that. So now they're seeking to have you jailed until you respond. Okay, is there anything incorrect about what I said, Mr. Mason?
No, Your Honor, we did send the OCD letter, I believe, on, it's right here, September 18th is when the court entered their order. We sent that advising the defendant of the court's order on September 24th. We've sent the good faith letter. We have not heard anything from this defendant since sending that stuff. And Your Honor, just for the court's full information, of course, I think the court already knows this from reviewing our pleading in the form of this motion, that it is a rather small amount. It's, I believe the res is $2,250 plus interest. I believe brings it up to $3,760, and then reasonable attorney's fees in the amount of $750, Your Honor. So it's not a large judgment. So while I personally never really take any solace in having someone incarcerated for a contempt of, Your Honor, I just want the court to be aware of that. But that is what we're asking for, Your Honor, because I just oftentimes.
Mr. Mason, may I suggest an alternative?
Certainly, Your Honor.
I have the ability to put you all in a breakout room, and maybe because Ms. Williams, I don't know if there was an issue with her registered agent. It seems to be between her and her registered agent. However, prior to me issuing an order to put Ms. Williams in jail, is it possible that maybe you all can communicate, because Ms. Williams may not have had a clear understanding of her responsibilities with respect to responding to the post-judgment inquiries? Is it possible that you all can go into a breakout room, exchange information, and then if necessary, I can reset for the contempt hearing, but you may just get the information that you're seeking?
Your Honor, I think that'll be preferable given the amount of the judgment.
All right, I thank you for that. So Ms. Williams, so a lot of what I do on these civil hearings is I teach business law. Unfortunately, a lot of people operate businesses, but they are skilled and knowledgeable about the type of business that they operate, but not so much the law. And unfortunately, when you have gaps in your knowledge with respect to how you legally must run a business, you sometimes have these things happen where you don't protect the business's interests because there are things that you're not aware of. Okay, so my understanding is that there's an issue, I guess, with you having received notice from your registered agent that you need to address with the registered agent that you hired to protect your business. But at this opportunity, I'm going to give you the opportunity to speak with Mr. Mason and exchange information with him, because what he is seeking is documents for the default and for collection of the amount of the judgment. If you are willing to do that, then at this time, the court will hold off on having the contempt hearing and possibly issuing an order that would result in you being jailed until you complete the information.
Okay, I never even heard of this company. So, okay, I don't even know who this is. Okay, I don't know who this company is.
Ma'am, that unfortunately, when you don't receive, when you receive the notice of a lawsuit, that would have been your opportunity to defend and say, I don't know, or I'm not sure what's going on. Mr. Mason can explain some of these things to you, but I'm giving you the opportunity to go ahead and speak with him. But please understand that a lot of times people think they can operate a business without the assistance of an attorney at any point during the life of the business. But I dare say that sometimes you might need to sit down with an attorney, maybe periodically, maybe quarterly, maybe yearly, to figure out what things that you need to know to protect yourself and your business.
Okay.
We're lawyers are dispensable until we are not. And as I used to tell my clients when I was a business attorney, it's best to come to us when you're anticipating something and you're wanting to build a business, instead of coming to us on the back end when we're having to defend and possibly missing out on some information that we should have had. Okay.
Okay. If I
All
had,
right.
I would have came. The first time I seen this is in December.
I got you. I'm going to put you in a breakout room with Mr. Mason. Mr. Mason is going to explain as much as he can about what is going on and about the information that he needs. You all exchange information, and once you all have exchanged information, you can take your discussion offline. And if need be, I'll set another date in the future if you aren't able to come to a satisfactory conclusion. But at this time, you all have the opportunity to speak without me taking any action to put you into a kind of a negative position. How's that?
Jail.
Yes, ma'am. Under the law, if you are held in contempt for failure to respond to post-judgment discovery, one of the sanctions is that you can be jailed until you complete that. And when I was in magistrate court, I would just have people come in and sit in my courtroom until they did it. I don't have the same options in state court. Okay.
Okay, because I only see September and October.
Okay, I get that, ma'am. What I'm telling you is I'm going to give you the opportunity to get more information. I don't have.
Okay, thank you.
All right, so I'm going to put you in a breakout room with Mr. Mason. And once you all have finished speaking, you all are free to go. But I will reset this case if need be, if you all aren't able to come to a conclusion, okay?
Okay.
Your
All
Honor,
right,
would
so
you like us to, I'm sorry, would you like us to come back from the breakout room and report the conclusion of our?
No, just send a chat. You can come back, but just send a chat to Miss Kiera Powell, who's my staff attorney. But Miss Williams, you should, when you activate your screen with your cursor or your finger or whatever, you should see an invitation to the breakout room number 1. Mr. Mason will meet you in there and you all can have an offline private discussion, okay?
Okay, thank you.
Thank you, Your Honor.
All right, thank you. All right. So next is Assurance America Insurance versus Josiah Johnson.
Ron Lockley for the plaintiff, Your Honor, and I have a witness here, Miss Ashley Taylor, to testify regarding damages.
All right. Is there anyone here on behalf of the defendant, Josiah Johnson?
I'm here for myself.
All right, Mr. Johnson, please, can you turn your camera on for me? Okay. All right. 1 second. So, Mr. Johnson, this is an automobile accident. They filed a complaint in August of 2024. They said that there was service at your home, and then that was in October 1st of 2024. And as of December 10th of 2024, when the court entered a default judgment, you had not answered with the court.
Yes, ma'am. Yes,
Okay.
Your Honor.
So because of that, they've been granted the default judgment. Now they just have to prove the damages. Even though you did not participate in the underlying case, you can, if you have evidence that would change the amount of the damages that they are presenting, then you can question that, or you can present evidence on your behalf regarding the damages, just not the judgment. Okay?
Yes, ma'am.
All right. So, Mr. Lockley?
Yes.
All right, so Mr. Lockley, who's your witness in this case?
Taylor Johnson.
All right, Ms. Johnson, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right, your witness, Mr. Lockley.
Ms. Johnson, please state your name for the court.
Taylor Johnson,
And with whom are you employed?
Assurance America.
And in what capacity?
I'm a claims adjuster
And how long have you been employed in that capacity?
for 8 years.
And by virtue of your training experience, are you familiar with the fair market value of vehicles before and after collisions?
Yes.
And are you familiar with the reasonable cost of repairing damaged vehicles?
Yes.
All right, I am going to share my screen. Hopefully that's okay with the court. Can you see notice of documents to be used at trial on the screen?
Yes.
Okay, this first document, this is Exhibit 1. Is this the police report for which the claim was filed?
Yes.
And the police report indicates that the defendant's vehicle sideswiped our insured parked vehicle?
Yes, that is correct.
And this police report was retained in the ordinary course of business?
Yes.
Your Honor, I would tender this police report as Exhibit 1.
All right. Any objection, Mr. Johnson?
No, ma'am.
Okay, will be admitted as Exhibit 1 without objection.
And this document that's marked as Exhibit 2, is this the preliminary estimate that showed the detailed damages to the vehicle as a result of the subject collision?
Yes.
And the amount of the damages for the repairs, although this wasn't paid by assurance for this off this estimate, that's $10,192.
Yes.
And this document was retained in the ordinary course of business?
Yes.
Your Honor, I would tender this Exhibit 2 to the record.
All right, any objection, Mr. Johnson?
No, ma'am.
And in the amount you stated was $10,192, sir?
Yes, Your Honor, but this is a total loss, so this was not the amount that we paid. This was just the
I got you. I
estimate of
just
damage.
like to keep track of the numbers. Exhibit 2 will be admitted without objection.
Thank you, Your Honor.
Mhm.
And Exhibit 3, these documents, do these show the photos of the damage to the vehicle as a result of the subject collision?
Yes.
And were these photos retained by the insurance company in the ordinary course of business?
Yes.
Your Honor, I would tender Exhibit 3 to the record.
Any objection, Mr. Johnson?
No, ma'am.
All right. Will be admitted without objection.
Scroll down. There's a lot of photos here. The document marked as Exhibit 4, is this a market valuation report that shows the actual cash value of the vehicle just immediately prior to the collision?
Yes.
And the amount of the vehicle, including the amount of the value of the vehicle, including tax and title and its value itself, what is that amount?
$12,115.07.
And this document was retained and prepared in the ordinary course of business?
Yes.
Your Honor, I would tender Exhibit 4 into the record.
Any objection, Mr. Johnson?
No, ma'am.
All right, Exhibit 4 will be admitted.
What was the value of the vehicle? Let me see if I can change this. Whoops. All right, Aaron.
It's about to get real interesting, Mr. Lockley. Be careful.
Yeah, that was just a video game thing. I
I
was trying to
used
find
have
out.
to swipe on people's phones in magistrate court, and a couple of cases cured me of that.
Sorry, Aaron. This is this document marked as Exhibit 5. Well, what was the value of the vehicle after the collision?
It was $2,377.
So what is the total difference of the vehicle before and after the loss?
$9,738.07.
And this document marked as Exhibit 5, is this the payment history of the payment made to the insured prior to recovery of the salvage, which was the value of the vehicle after the collision?
Yes.
Your Honor, this is we tender Exhibit 5 to the record.
All right, any objection, Mr. Johnson?
No, ma'am. I would like to ask, will I be able to say something after they give their evidence?
Sure.
All
All
right.
right. It will be admitted, Exhibit 5.
So, Ms. Johnson, what was the total amount of property damages resulting from this collision?
$9,738.07.
Your Honor, that's the principal amount we seek in addition to post-judgment interests and court costs.
All right.
And that's our case, Your Honor.
All right, Mr. Johnson. So the plaintiff is pleading for the amount of $9,738.07, which from the initial value of the vehicle prior to the collision to the loss value and the salvage value after, that's what would have remained that remains unpaid or unaccounted for, okay? So that's what they're asking the court for, $9,738.07 plus post-judgment. So by law, there's an amount of interest that can be granted until the debt is paid. That's the post-judgment interest. And then the court costs are generally in the amount of like $200 and something just for filing the case. Okay, so Mr. Johnson, did you have any questions about the evidence that was presented?
I was just gonna ask if I could like settle that amount because during the time the accident occurred.
Hold on. So let me just tell you, you're not challenging the amount. So the court is going to grant the judgment in the amount of $9,738.07 plus post-judgment interest and court costs. Now that the judgment has been entered, you have the opportunity, if Mr. Lockley's clients are willing, to speak with them about a payment schedule, about settling the judgment, any of those options. Mr. Lockley, is there information that you can provide to Mr. Johnson about whom he can contact regarding settling this matter or payment of the judgment?
If he could provide his email address, I will send him a proposed consent agreement of settlement, which would be monthly
Mr. Johnson,
payments.
do you know how to use the chat function? Mr. Lockley, if you could stop share screen for me.
Oh, I'm sorry.
No problem. Mr. Johnson, do you know how to use the chat function?
I'm working with right now. I think I see where it says chat right now.
Okay, so when you're chatting, listen to me closely. When you see the name in blue, there's usually a name in blue. It says everyone. Click on that and look for Ronald Lockley and send your chat directly to Mr. Lockley. Okay, you want to include your first and last name, your email address, and your phone number.
I will do.
All right, Mr. Lockley, you can send an order if there wasn't one provided in your pre-court filings. You can send a judgment order to Ms. Kiera Howell by email.
Thank you, Your Honor. May we be excused?
All right. Have you received the information from Mr. Johnson?
He just typed his name, Josiah Johnson.
Okay, Mr. Johnson, you can put all of the information in the chat, that your phone number and email before you send it. You don't just have to send it one thing at a time, okay?
Yes, ma'am.
All right.
I have it, Your Honor. I'm going to write it down and then I'll leave the court if that's acceptable.
Yes, and Mr. Johnson, the next time someone shows up at your house and they're serving you with service of process, or they leave papers at your house, read them carefully, sir, because you lose the ability to protect yourself and your interests if you don't respond, okay?
Yes, ma'am. I tried to contact the judges for Clayton County, and I
Okay,
talked to her.
you can't contact us. There's a method by which you can respond. It's spelled out in the summons that's attached to the complaint. You don't just call the judge, okay? read the paperwork carefully, and if you're not understanding it well, go to somebody who can help you work through it, okay?
Yes, Your Honor.
All right, thank you, sir. You're excused at this time. Next is Midland Credit Management versus Elfrida Doe.
Good afternoon, Your Honor. Courtney Baker for the plaintiff.
Good afternoon, Ms. Baker. Is there anyone here on behalf of Elfrida Doe?
Yes, I'm here.
All right, so Ms. Doe, you've seen how this works. Is there anything that I need to explain to you before we get started?
No, ma'am.
Okay, so it appears that there was a case filed. They served you personally on September 1st of 2024. You did not file an answer in writing with the court, and therefore they've been granted judgment in this case. Now they just have to prove the amount of the judgment. If you have any information that would change the amount granted, then you can ask any questions that you have or provide any evidence of that, okay?
Your Honor, I did file an answer with the court.
Okay, when did
I
you?
filed my answer. I got the paperwork on it was dated for August the 16th, 2024. And
That's the date the complaint was filed.
And it said I had 30 days to respond, and I filed my answer on September 6th.
Okay, it says that you were personally served on September 1st of 2024. It says, and you say you filed your answer on September 6th?
Yes.
All right, we're checking.
Your Honor, I believe that is correct. We, however, did not have a copy of her answer.
Okay. You weren't, so Ms. Doe, when you filed it, did they direct you how to file it electronically?
No.
Okay, so you filed it in paperwork?
Yes.
Okay, and you didn't send a copy to the other side, you just filed it with the court?
Yes, I just filed it with the court.
Mm-hmm.
They didn't tell me that I needed to send anything to the other side. They just stamped it and gave it back to me.
Yeah, they're not allowed to give you legal advice, but the summons on the front of it. Okay. Ms. Powell, if you can find it, is it something that you can like show me? Can you pull it up so that I can see it?
Yes, Judge, would you prefer me to share my screen or would you like me to email it to you really quickly?
Email it to me. And Ms. Williams, Yvonne Williams is on asking if we have called her case. Let me go back because I believe I did call a case involving Yvonne Williams.
That's the lingering case from the 11 o'clock calendar with Mr. Bell.
Ah, yes. So, Ms. Williams, we did call your case. The problem was we were unable to, Mr. Bell was unable to technically get on. So I said that you all could come back at the 1 o'clock. So we haven't heard your case yet. You are still timely, but it was on the 11 o'clock calendar. Mr. Bell was having technical issues. He was here 1 minute, you were here 1 minute, and then both of y'all were gone. So we'll hold that and hear it. All right. So let me know when you've sent that, Miss Powell. All right, so Ms. Doe, Ms. Baker, hold on for a moment and let me get back to you, okay?
Okay.
All right, so for the individuals on Shaw versus Riverwood, about how long do we anticipate this matter taking?
Your Honor, for the defense, Ann Rogers is going to be arguing it as defendant's motion for sanctions. I believe, Ann, you're on mute, but I think she told me 15 or 20 minutes, but I'll let her weigh in.
Yes, 15 or 20 minutes.
Okay, and for the well, I guess I'll give you the opportunity to respond. All right, so Ms. Rogers, this is the hold on. All right, let's hear it. So this is the matter on for the court reporter who's been incredibly patient with me, Ms. Richards. This is State of Georgia. I'm sorry, this is Shakia Denise Shaw as plaintiff, Robert Shaw as plaintiff, Willie Banks as plaintiff versus Riverwood Housing Partners, John Doe's 1 through 5, Jeffrey Morley. The plaintiffs are represented by Brian C. Mickelson and Daniel Beer and Michael Joel Smith. The defendants are represented by Joshua Wood and Ann Rogers. And this, it seems, there's a motion for contempt, I believe. Wait a minute, did I read that properly? Well, I'm sorry, motion for sanctions, and a motion for emergency leave to amend. All right, so let's go with the Ms. Rogers.
Great, thank you, Your Honor. Before we get started, we've prepared a brief PowerPoint just for demonstrative purposes. We'd like to go ahead and request permission to share that PowerPoint and share, if I could share my screen with the court.
Okay.
Great. Okay. Okay, can everyone see my screen?
Yes.
Okay, great. So as Josh said, Ann Rogers and Josh Wood with Weinberg Wheeler on behalf of the defendant, Riverwood Housing Partners. Riverwood Housing Partners owns the property where Robert Shaw was shot and killed on October 10th, 2022. The issue before the court today is that the plaintiffs have concealed the identities of key witnesses in this case, failed to produce key evidence and information regarding how the shooting occurred from the defendants in this civil lawsuit. But when the defendants produced to them the Clayton County Police Department file that has the information that the plaintiffs gave to the police that says the opposite, the plaintiffs claim that they were under no duty to produce that to the defense because that information constitutes, as they claim, rank speculation, rumors, and ultimately, as they have decided, inadmissible hearsay. But that is not the law in Georgia. If that were the law in Georgia, discovery would be a litigant's tool to fool their adversary instead of the fact-finding tool that the Civil Practice Act demands it to be.
Okay, so I'm sorry to interrupt you, Ms. Rogers.
Yes, Your Honor. I'm
not a jury, so you don't have to like line it out for me. My understanding of the facts is appreciate from the motions is that there was a shooting. It was alleged that he was there as an invitee visiting a person who lived at the Riverwood Apartments, that during the course of the visit, he was accosted and killed on the property. But once the information got to the police, it was determined that either a relative or some person related to the decedent had information that they then took to the police that he may have been there not to visit the person who was listed as the person who invited him there, but as having a conflict with another individual who was totally unrelated to the person that was alleged to have invited him there. And then the person who was alleged to have invited him to the property made statements that would have amounted to, she had nothing to do with this, she had no clue, and the only connection she had to the decedent was that she knew his sister. Am I correct?
Yes.
All right,
yes.
So take it from there.
So the issue then before the court is what the plaintiffs did not provide to defendants in discovery. So we served basic standard discovery requests asking for what all litigants ask for in every case, right? Witnesses, evidence, and information. And the plaintiffs responded to us with the same claims that they've made throughout this lawsuit. that Robert Shaw was on our property to visit a friend. This shooting was random. That's number one. That Robert Shaw did not know his killers. That's number two. And then number three is that the plaintiffs do not know how this shooting occurred, aside from a few basic facts. Those basic facts being that he was on the property to play basketball. In the course of our own investigation, we subpoenaed the Clayton County Police Department's file. As we reviewed that file, we came to realize that the plaintiffs know a lot more about this shooting than what they provided to us. They know, or would seem to know, what happened, would know the identities of key witnesses, and have concealed from us witnesses, evidence, and information that indicate what the motive and reason for this shooting would be. Those are key issues in a negligent security case. So the responses at issue that we've raised with plaintiffs' counsel hit on those three areas, and we are going to address those briefly in turn. So the first area of inquiry that we asked about was people that have knowledge about what happened in this case. Basic request. We asked plaintiffs in interrogatory number 10 to identify any individual that has any knowledge, information, or opinion regarding the facts and circumstances surrounding the subject matter of this case. Plaintiffs then responded and said they identified the Clayton County Police Department officers, they identified the perpetrators, they identified the victims, one witness, a female witness, an employee, and Shamira Payne. But after reviewing the police file, we come to find out that the plaintiff herself, from the day of this shooting, has accused her daughter of being the key witness in this case. How do we know this? Detective Gant's probable cause warrant in this case for warrants for cell phones and various things contains a summary of his interview with Shakia Shaw, in which she summarizes, Shakia advised that she'd spoken with her daughter, Nikira, after the shooting. She had found out from some friends that Robert was shot during a confrontation with a guy named Bastard, a friend of hers, right? That is not what they told us. They never, ever identified Nikira Shaw. In fact, this is what she told Detective Gant on the day of the shooting, immediately following that.
If you're playing it for me to hear, I cannot hear it. Sometimes there's a requirement that you go to your settings to allow it to play audio. This has happened before.
Let's see, maybe if I mute my...
Nope. It's actually embedded in, I guess, the video. Something has to allow you to play the audio over Zoom. We've had this happen before.
Audio. Let's try this, and if this doesn't work, then we can move on from the video.
Okay, this blue line here. Can you move that for me? This blue dot. Yeah, that. Can you move it?
No, that's from the original video. That's okay. We can. Let's see.
All right.
But these videos were attached to our motion for sanctions. And so the video is plaintiff Shakia Shaw saying to Detective Gant that Nikira knows what happened. It was a friend of hers that came to visit on the day of the incident, who she then told where her brother was. He was down the street. It was over a gun. And then the detective in that video asks her in the first video here, the detective says, why would she set up her brother? Why would she do something to put her brother in danger? And she says, because Nikira's in a gang. So the plaintiff in this video explains to the detectives in the criminal case that Nikira Shaw knows exactly what happened in this shooting, that she's the most important witness in the case. but she's never identified to the defendants in the civil case. Without the police file, we never would have known that Nikera Shaw even exists. That's the first piece of evidence, key witness that was not disclosed to us. The second piece of evidence, and the police file, which we've attached and we've produced to plaintiffs and attached a good bit of it to our motion, contains numerous examples. We're hitting on three pretty big ones. The second would be evidence about how the shooting occurred. So the interrogatory, we asked for basic evidence, describe, any information you have, any pieces of demonstrative evidence you have that indicates how the shooting occurred, the motive, what happened in this case. Plaintiffs responded. Plaintiffs have produced a gang-style music video created on the premises. That was the response. When asked if Robert Shaw has an Instagram, a social media, plaintiffs responded. Plaintiff does not recall any social media accounts for the decedent. Then, in the next video, or the summary of what the next video would be, this is Detective Gant's summary. He says, Ms. Shaw showed me a conversation on her phone that she alleges is between Robert and one of the shooters. They appear to be trying to meet up on the day of the murder on Flint River Road. In the next video, that is a portion of the full-length interview that was attached to our motion, Ms. Shaw says Robert has an Instagram account. His Instagram handle is @2playa_little_red, and that Nikera went in and deleted all of his pictures immediately after this happened. So we know he's got an Instagram account. We know that Ms. Shaw has provided the police with these messages that indicate that Robert Shaw had a pre-existing relationship with one of his killers, a key issue in a negligent security case. And what we were told in discovery, affirmative response in discovery, is that all plaintiffs have is a gang-style music video created on the premises. Finally, the last area of inquiry that we asked about in discovery is just information on how this shooting occurred. What does the plaintiff know about the facts of this case? Plaintiffs both responded to us. The plaintiff is aware of the basic facts of the subject incident. The plaintiff explained the decedent was visiting with friends and playing basketball. But then the plaintiff also says, again, repeats, visiting friends, playing basketball. But then she tells Detective Gant again in this interview, the day the shooting happened, that Robert Shaw and Cameron Jones were on the property. They got in a fight with guys trying to take Cameron's gun, and that's how this happened. No mention of basketball, no mention of being there to visit a friend, that this was over a gun. None of that information was ever provided to the defense. Again, other areas of inquiry that we asked about was the decedent a member of a gang? Nope. Responds no, he wasn't. Then we see in the police file that there's reports that Robert Shaw was a member of a gang. There's photos of him in the police file throwing gang signs on the day of the shooting. So we see this and we come to realize that we have not received complete, accurate, or truthful responses to the discovery that we serve. And the question is, why? Why not identify Nikera Shaw? Why not identify Rita Shaw, the family members that are saying that this was over a gun, that have information on the elements that establish a negligent security claim? And the reason is because that information, the evidence, the witnesses, the information not produced to the defendants in this case changes this case. It hits at those four elements. It changes whether or not this was random. It changes whether or not Robert Shaw knew his killer. It changes whether or not the plaintiffs know what happened. It's the difference between a viable negligent security claim and one that is not. So here's where we are, Your Honor, in this case. Procedurally, we served discovery in April. The plaintiffs responded in August. We subpoenaed the police department's file. We reviewed it and we produced it. Before we produced the file, we called Brian Mickelson and we said, we're going to send you this file and we're also going to send you a letter that outlines what we believe are some serious issues with plaintiffs' discovery responses. After that, there followed multiple phone calls, multiple emails in which we discussed these issues. After that, there are now 2 lawsuits, one in DeKalb County and one before this court. Plaintiffs have sued additional defendants, and our clients are in the position of defending 2 suits. And we have said
the suits both have the same nexus of operating facts.
Yes, they are the exact same.
Both about the death, about the decedent's death on the particular property on the same day.
Yes, Your Honor.
Okay. Which case was filed first, Clayton County or DeKalb?
Clayton County. It's against the additional defendants that plaintiffs were trying to add through, or are trying to add through their emergency motion. Defendants have represented to plaintiffs throughout this entire process after they moved to add these parties that we will not object to that. And the last email we received on that, when we asked counsel if they were going to file a motion to transfer, is that they are waiting to see what the outcome of this hearing is before moving to transfer and consolidate those cases. So that's where we are, 2 lawsuits procedurally. We have asked plaintiffs over and over and over again to verify their responses. They will not do it. We are not going to put emails in front of the court as evidence, but the explanation that we've received from plaintiffs' counsel is that they don't know what other information that the defense may be sitting on, and therefore they will not verify their responses. Your Honor, we're not sure what the basis is.
That seems counterintuitive, since if you're seeking redress of a harm, a tort, and you're seeking damages, then you have the burden, and the burden is to provide a complaint that outlines what damages you're seeking, the mechanism of what caused those damages, and what the defense might find shouldn't have any bearing on what is the truthful presentation of your request for redress of damages.
And that's ultimately why we're here, is because we just see no other avenue for relief for our clients. Because to Josh and I, it doesn't matter if you are the plaintiff or defendant. It doesn't matter if the information helps or hurts your case. The Civil Practice Act is clear. If it's relevant and discoverable, it doesn't matter if it's ultimately inadmissible. You have to produce it to the other party. That is the rule. I mean, and I know that we know that there was a supplemental brief filed 2 days ago, I believe, in front of this court. And we want to address that as well, because those affidavits, the affidavit of Ms. Tuggle is saying that moots our motion, that our motion should be thrown out and that they should be granted their fees. Your Honor, this affidavit has absolutely nothing to do with whether or not the plaintiffs have provided complete and accurate discovery responses. They have not. But there's 3 points that we want to make quickly on this, and then we will move on. The first is that the plaintiffs are correct. Josh and I did produce this to them before this hearing because, as we've said, as lawyers, we do not make the facts, but we do produce the information that we have, and we go from there. That's what you do in discovery. There's no other way to say it. Then, if we look quickly at what this affidavit is saying, Ms. Tuggle says that on October 10th, 2022, she was a resident of Riverwood Townhomes. First of all, we cannot find any record to suggest that Ms. Tuggle had a lease or was ever had any type of legal relationship or lease with our property. That's beside the point. She then says in paragraph number 5, upon information and belief, this young woman was Shamira Payne, that she says that Robert Shaw was visiting. But an affidavit has got to be based upon your own personal knowledge. So to us, there's some serious questions about whether this affidavit at all has any evidentiary value in the first place. But even assuming that this affidavit and everything in here is true, even assuming that whatever Shamira Payne is saying is true. That does not
At most, it's a question of fact for a jury to determine.
Exactly. And we're not here, this is not a motion for summary judgment. We're not here, you know, as plaintiffs have suggested in their response to our motion, we have not solved Robert Shaw's case. That is not what this is about. What this is about is that we as defense attorneys can't go to our clients anymore and say, you know, it's demand after demand after demand. And we know you've seen the police file that says the exact opposite of what the plaintiffs are telling you, but you should believe them. You should take that at face value. We just can't do it anymore. And we can't even get verified discovery responses. That is not the way that this is supposed to work. It's supposed to be an even playing field, no matter what party you are. That's the basis of our motion, and that's why we're here. Thank you for your time, Your Honor.
All right, if you'll stop share, let me talk to the other side.
Your Honor, this is Josh Wood. Can I ask you one question? Would it be appropriate to supplement either email the PowerPoint? You have basically filed as evidence the whole police file. We isolated the clips, but it's huge and it's often hard to see. I think personally those clips are very important. I don't know if we can put it as an exhibit. Yeah. We can mail it if you find it.
I mean, let me just say, the fact that I remembered all of the facts of this case off the top of my head, I wasn't looking at my notes. My staff attorney and I talked about this case months ago when I set it for a hearing. So the fact that I remembered this, I mean, I was a magistrate judge. I've done probable cause hearings. I know Detective Gant because I've given him search warrants and arrest warrants. So I'm, familiar with how this works. So, if you want to present it, that's fine. But that's up to you if you want to supplement. Mr. Mason, is there anything I can assist you with before I release you?
Your Honor, I was just letting your staff attorney know via the chats that after talking with Ms. Williams, she has assured me I'm going to make sure she has a fresh copy of our PJD. And she has assured me that if I continue this, she's going to have all that answered before whenever that date would be. So I believe her, Your Honor. So I would just be asking for a continuance on that to give her a chance to answer our interrogatories and whatnot.
Thank you for being so patient and kind I know you have the advantage in the case, but at least to be willing to work it out. So we'll give you a continuance on that and just let us know if we have to put it back on the calendar.
Excellent. Thank you, Your Honor.
All right. Thank you. Okay, Ms. Doe, don't think we've forgotten about you. We found the information and we think it was misfiled it came in and was filed sort of like as a response, but not an answer. So now that we have the answer, we can talk about that. All right, so I was just trying to go back and address some things before we hear the response from plaintiffs in the Shaw case.
Yes, Your Honor, you ready for me to respond?
Okay.
First, good afternoon. I want to start by saying that, for my firm and Mr. Beer and I, we were brought into this case after, I believe after Mr. Wood sent his letter. And so we take this, but we do take motions for sanctions very serious. I think in my legal career, maybe I've only seen a few of them, and I think rightfully so, because these are very serious motions. In particular, the sanction that they're asking for in this case is what is well recognized in Georgia as being the harshest sanction, and is usually reserved for what is called generally the most egregious cases that one has seen. So in talking about this and in thinking about the motion that was filed by the defendants, I kind of want to start with just the process that was deployed in this case, in that I'm unaware of a case involving sanctions of this magnitude where—
Okay, you're arguing the sanctions.
Yes.
You're not telling me why I shouldn't consider sanctions, and sanctions have a range. I can go from telling you that I'm going to exclude evidence. I can go to attorney's fees or fees against the plaintiffs themselves. I can go, there's a long range, but I can strike an answer. Before we get to that, tell me why what they're saying shouldn't carry weight with me, because like I said, I remembered the facts of this case off the top of my head. One, I'm not sure why we can't get a verified complaint from the plaintiffs based on what they're alleging happened. Two, I'm not sure why we're now having information that's contradicted by the police file for a complaint that was brought. And three, tell me why I'm wasting my time on a complaint here when the same complaint is with one of my brother or sister judges in DeKalb, and why shouldn't I just let them have it? Because I got enough on my plate.
Well, to start with, why there's a complaint in DeKalb, we filed that mainly because out of concerns for the statute of limitations, Your Honor. Like, we didn't want to risk the prospect of not getting a ruling on our motion, and so we filed that complaint in DeKalb just to preserve our client's claims and make sure they were presented in a timely
Yeah,
basis.
but if your client's claims don't sound in truth or if they're not proper here, where I assume venue exists because you filed it here first, then they wouldn't be proper in DeKalb. You just putting double work on us. So you're saying, Judge, we're forum shopping in essence. We don't like it. It's not something that can be subject to a transfer because of a lack of venue or shifting venue, but we're going to try and see if the other judge might make a different decision. What I want to know is, let's talk about this case. Why can't we get a verified complaint? Let's start there.
Well, we start with the verification. Our concern there was we want to sit down with our clients and verify our responses. Our perception of the sequence of events that occurred was that it was perceived to us that there was some gamesmanship being played by the defendants in even bringing this motion.
Let's stop there, because you're telling me what they are talking about. What I'm saying is you initiated whoever, you may have been brought in later, but you all initiated this complaint. I've initiated complaints. I did civil before I took the bench. So a lot of people don't understand that. I understand the Civil Practice Act. I know what's going on. They may have updated it since I practiced, but I've been a judge, so I'm responsible for those updates. What I'm asking you about is, A, why can't we get a verified complaint? You can file a complaint without it being verified, but you can also verify it after. Has nothing to do with what the defendants are doing. There's no gamesmanship that affects your ability to put an indicia of truthfulness with respect to the complaint that you filed. So why can't we get a verified complaint? That we haven't sat down with our clients, then why has this been pending for a while and y'all haven't sat down with your clients?
We can verify the complaint, verify the interrogatories, Your Honor. I don't think it's about verifying the complaint. We can verify discovery responses. We can have verification in the next day or so.
I want it all verified. I want the complaint verified and I want the responses verified.
We have no objection to doing that, Your Honor. We can get that done.
Okay, you got 7 days to get me a verification on the complaint and on the responses. Now, before you verify responses such that I'm going to hold you as a member of the bar responsible for any incorrect answers, then I'm going to need to make sure that those are verified and correct to the best of everybody's knowledge. You know what's out there with respect to what the defense has presented. So you know if there's some verification on something that's shady, I'm already looking at it.
Yeah, we have no problem with that, Your Honor.
Okay, 7 days for verification of the complaint, 7 days for verification of the discovery responses. And that means updating the discovery responses.
Yes.
Okay. All right. Now, with respect to the request for production of documents for number 4, where it says all documents relating to fees paid to you as an investigator by the law firm of Weinberg Wheeler and other law firms representing defendants in actions involving claims for negligent security during the last 5 years. That's way too broad. Way too broad. If you want to do it with respect to this particular case and what's been paid, I'm fine with that, but not for negligent security claims for the last 5 years.
And Your Honor, we've already agreed to provide everything related to this case from Mr. Morley and from us. The only objections we had is what Your Honor brings up. Anything outside of it. He works as a private investigator. I don't know what other cases he's working on. And all he did was take statements.
Yeah.
Thank you.
Yeah, we're not going to be overbroad and expand this litigation. I've done premises liability, wrongful death cases. I've done cases where I've had to initiate severe sanctions. And that happened over the course of time. It was thing after thing after thing after thing that I had to consider. But we're not starting off a case where we're already, it's a lot of gamesmanship. And if you're saying that the defendants, by finding information that is available in the public forum and presenting that information, that's gamesmanship, as opposed to you all filing a separate civil action of the same operating facts in DeKalb County and Clayton County and maintaining both of those. I'm not sure gamesmanship, I don't know that I would use that.
Well, one clarification, Your Honor, the DeKalb action involves different defendants. It's not the same defendants.
All different defendants?
All different
there
defendants.
There are no common defendants.
No, Your Honor. There are no common defendants in the DeKalb action. The DeKalb action is against the property manager, which is not named in this suit, and then also another entity that is not named in the current suit.
Okay, so you know that
it's who they allege to be.
Those are individuals who should necessarily be named in this suit. You can't bring a separate action for the same nexus of operating facts, the same date, the same occurrence, the same people, the same location, and then say, well, we're going to leave out the property manager so we can then file against him in DeKalb. He's a necessary party to the complaint that was filed.
And that's why
that's gamesmanship.
Well, that's why we filed emergency motion to add, but we didn't get a ruling before the statute was about to run, Your Honor. So to preserve to make sure we didn't run past the statute, we filed the case in DeKalb.
I will let you add anybody you want to add to this lawsuit. That is not an issue for me.
And so we wanted to, but we were past that. We're past
I
the
don't
statute.
care. You're going to have leave of the court to add whoever you want to this lawsuit in Clayton County.
Okay.
Your Honor, our clients are currently in the position with the pending DeKalb lawsuit. We have several outstanding discovery requests that we're trying to respond to. Like I said, we're defending 2 lawsuits.
Okay. Hold on, Ms. Rogers. You all have filed against 5 John Does in this Shaw case. So I'm not sure why. I mean, you've already basically got 5 people here. You have room to add 5 people, just name them. So I'm not sure why the DeKalb was necessary with all those other parties, but I'm going to tell you right now, we'll get an order out to you that you are allowed to add anybody you want to add to the lawsuit. I'll give you leave.
Thank you. And Your Honor, just so we can move on from this, we've already told them we don't oppose it. We just want to be before one judge, and the DeKalb action should be transferred to you. And by the way, there's another one. And I see Ms. Fairley's joined. So, but what happened in this case, Robert Shaw was shot. There's another person, Jones, that has filed a lawsuit, and it's before judge. We filed a notice of related cases. It's down the road. I think someone can correct me. I think it was Judge Spence who has it, but I can give you the name. So we filed a notice with Judge Spence and with you. We believe under the rules.
Judge Spence in where? What
in
county?
Clayton County.
That's Judge Spencer. Margaret
Spencer. I'm sorry.
Yeah, you need to, she has the older case. So as long as she knows that they're related, or we can talk about it, but both of them should come to me. And in DeKalb, do you know which judge that case is in front of?
I think it may be Judge Wong. I can double check. But I can guarantee you when we tell Judge Wong you're ready to get it, we can have it to you as quick as you want it.
Yeah, Al will send that to me on roller skates. All right. I wish y'all had filed with him first. All right. So let's be all right. So let me just tell y'all a couple. I'm not new to this. I practiced civil practice for quite some time. I did some administrative stuff. And when I took the bench, I did magistrate court for 4 years. And then I came up to state court. So civil practice is where I started. This is not new to me. I like clean litigation. I don't like gamesmanship. I don't like holding stuff back that should be produced. I don't, if you're asking, if you as plaintiffs want recovery, then you got to be willing to give. And under the Civil Practice Act, reciprocal discovery is what is that's the basis of it. So you all can't get if you're hiding things or if you're not responding to things in a true and correct manner. If information is coming to you that is negative for your case, you got to deal with it. The facts are what they are. And if we've got competing witnesses and competing information, I don't have a problem with getting it before a jury. You will get a clean jury trial and you will get pretrial orders that are clear and concise so we can move forward. Weinberg's been before me before. They know how I operate. And so we're not going to do all this back and forth. Now, I'm sorry that it took me a minute to get to y'all because I had staff attorney prior that some things went missing. I had to find some stuff. No problem. But now we're here. We're 4x4. I know what's going on in this case. I need y'all to start dealing like professionals. Not, you know, the DeKalb case needs to go. The related case is probably going to come to me. That's before Judge Spencer. I'm sure she'll be glad to give it to me. But let's be clear that I see stuff, I look for stuff, and I pinpoint stuff, and I'm not going to hold back. I don't like gamesmanship, and I don't like games. The individuals in this case, plaintiffs and defendants, deserve to have their day in court. And if their day in court ends with a summary judgment motion or a motion to dismiss, that's fine. But they deserve to have a good, clean litigation. So we're not going to do all this weird stuff. Let's get those. We got 7 days to get the complaint verified. We got 7 days to get the discovery responses updated and verified. And if that doesn't happen, then the sanctions will start. And I'll just move on up the line. I believe in graduated sanctions. So I don't go for the death penalty the first time, but please don't make me reconsider. We clear? Are there any other issues pending?
No, I
None
think
from the
that's
defense,
good.
Your Honor. Thank you.
Yeah. So
Anything from the plaintiffs?
no, Your Honor. I think.
All right.
Oh,
Because I like.
Oh, sorry, Your Honor.
When
Sorry, this is Daniel.
by the time I get to trial, let me tell you how I like trials to go. By the time I get to trial, we've done everything. And so I sit in trial and I face away from the jury because sometimes my poker face fails. The jury hears all of the information. And in the best civil trials, I rarely, if ever, have to respond to any objections in court because we've sussed out what evidence will be admitted or not admitted. We've sussed out what information will be redacted or not redacted. We've sussed out what information will be included in videos and not. And we've truncated those videos to the or redacted them to the point where they can be shown without being interrupted. This is how I operate. So please understand, I don't do attorney fights back and forth. I don't do that. What I like is for you to do what you know you're supposed to do professionally under the Civil Practice Act. We clear?
Yes, Your Honor.
All right. Now that I'm done fussing at you, tell me if there's any impediment to you doing what I've asked you to do.
Your Honor, just a question to get clarity. This is Daniel Beer for the plaintiff. Because it's pending with Judge Wong, is it okay? We're going to file a motion to transfer.
That's fine.
Okay. All right. Just want to get clear. That's what we're going to do.
And if you transfer it, I'll consolidate it into this case.
Yes, ma'am. Okay.
That's fine.
Your Honor, this is Natalie Drummond Fairley. Josh Wood mentioned my name, so I just wanted to introduce myself. I am one of the counsels on the companion case, Your Honor, and we have no objection to moving our case to your courtroom, ma'am.
Okay, that's fine with me too.
Okay.
All right, nice to meet all of y'all. Now you've met Judge Hayward. You know how I operate. Miss Powell is my point person. Miss Val is my scheduling person and my judicial assistant. If you're going to send anything to me, I don't do ex parte, so make sure everybody involved in the litigation is included in the information, and I don't do petty. So if you can work it out and talk to each other like professionals, then that's what I like. Consent, agree, those are my favorite words. All right?
Okay.
Judge,
Right.
before we wrap
Thank
with
you, Your
this,
Honor.
are we
Thank you,
also
Your Honor.
treating the Drew Eckel discovery as overbroad?
Did you say that you all agreed on something with that, Mr. Mickelson? I'm sorry, who responded to
I
that?
did want to get, I think Josh and I talked about this just because we figured it would come up at a deposition. So you're essentially saying, we need to constrain our case, our questions and inquiries to the investigator to solely his actions or work he's done related to this case, as opposed to because I feel like in a deposition,
you can,
there should
okay.
be, 'cause that was something that Josh and I have talked about.
It's
And
like how you say about experts. Well, how many cases have you done? Have you done more defense cases? Do you know how many defense cases you've worked on versus how many plaintiffs cases? Well, you can ask him if he mostly works with defense attorneys, but I mean, asking him what he's done for each case in the last 5 years is really overbroad because it really only matters what he's done on this case. If you already know that he mostly works for defense firms, then that's information you have, which you can use however you want to. But do you now have to know what he's come up with in each of those cases?
But Your
And
Honor,
that was, can I just say for our position, and my whole point is he's not even an expert. So I took over the defense.
That's what I'm saying. So
like in everything he did, he does interviews and stuff. He records them. We gave it to him.
And how is that not work product?
Well, because that's a great question, because he basically so they filed an affidavit, someone saying that the decedent may have been visiting her. Well, Mr. Morley, who, by the way, I don't represent, he's actually on the call if you have any question for him. He basically, he worked for Drew Eckel just taking statements, and the lady who's the witness told him, I don't even recall giving that. I don't know why they were there. This is the same thing she told the police and everyone. So we told them, hey guys, the lady who says they were there to visit is telling us they weren't there to visit. So we turned it over. They told me he's a witness now in the case. I don't really care, so I give it to him. I mean, if you waive work product, you can waive it as to a case and give it to him or something. And I did that. The problem I had was then getting a request to me and Drew Eckel that says, give us everything he's ever done and billed and collected for every firm.
That's a situation. Then if he's willing to waive work product as to this particular case, that's fine, but not for any other case, because it doesn't matter. What matters is what information is related to whatever affidavits y'all are questioning in this case. Well, and not only do you have access to the investigator in this case, you have access to the alleged affiant, Ms. Payne.
Well, and to the extent that he's been interjected as a fact witness, Your Honor, which is essentially what they did. They interjected him as a fact witness. Like I was thinking about along the lines of
witness, that doesn't negate the privilege that they have for work product for every other case he's worked on with Weinberg Wheeler. How is that possible?
To the extent that it would go to his bias. I mean, if he's working for,
if you can assume he's biased, they pay him.
Well, I mean, that's what.
By the way, Judge. By the way, that's not even true. I didn't even hire this guy. I don't even know him. We took him from another firm.
The point is that we would be able to.
Here's the thing, Mr. Smith. Sometimes a thing is just a thing. He did the investigation. You can put him on, you can depose him to determine whether he actually spoke to this person. You can depose Ms. Payne, show her a picture of him. Did you actually talk to this person, so that you can get the information that's necessary? But whether he did work as an investigator for this particular firm on other cases, whether he worked for other firms, is not germane to what you're trying to determine here. Whether he actually spoke to this woman and whether the information he alleges he received was counter to what she alleged in the affidavit that was produced in litigation. Am I wrong? If that's what you're looking for, narrow it down, because when we get into all this, we want don't paper them to death. That's just ridiculous.
Yeah, I understand that, Your Honor. Quite frankly, now that we're past the sanctions, most of this is probably going to be, it's going to, with Morley, quite frankly, it's just going to be a credibility stuff. So I'm not as worried about this at this junction, because it seems like, Your Honor, if we get him the stuff that we're supposed to get him with the verifications and do all this stuff, the rest of this should just be regular discovery anyway. I think the point
Well,
of
this whole thing should have been regular discovery.
yeah.
I'm
So
not sure, but let me just tell
we had a
you,
motion for sanctions filed.
have-
That I mean, rather than
well,
us
I
waiting-
get that, Mr. Smith, but if somebody tells me there's a companion case out, well, there's a criminal case out here where the criminal case is saying the exact opposite of what the civil case is saying, and I can't get any clarification on that, then I'm gonna ask some questions. And even if I ask for sanctions, I'm gonna think about, okay, look, is there enough here to ask for sanctions? But then if I'm going down the list and I got this thing, this thing, this thing, this thing, if I got, hey, he went to the apartment complex to visit Miss Payne and he was playing basketball. And then the counter in the criminal case is, hey, he went there about a gun. He was talking to somebody else. He doesn't even know Miss Payne. Hey, we've asked for information from the family about if they know anybody else who could possibly have any witnesses or information about how this happened. We don't know anybody. Hey, then you go to the criminal case and it's the family members who are providing information in the criminal case. And so when you start, you don't start at sanctions, but after a while, you get boom, 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 boom. If I remember the facts enough, and like I said, I talked about this with my staff attorney months ago. So if all of this sticks in my head, then you know it does, because it was prior to Ms. Rogers' presentation that I started telling you this. If all of this sticks in my head as fishy, and I said to my staff attorney, please, it was early October, as Ms. Powell is telling me, please put this on a hearing calendar, because this is not making sense.
Your
if
Honor.
I've done criminal, if I've given arrest warrants, if I've given search warrants, and I know I'm reading through search warrants, I'm reading through arrest warrants, I'm understanding what the police have to present in a probable cause hearing, because I've done hundreds of probable cause hearings. I've presided over them and I've argued them. So when I have all of that, I get why they would ask for sanctions.
Your Honor, if I may, this is Mr. Mickelson. I'm one of counsel for plaintiffs. I think some of the confusion here lies. I know that you said you know Investigator Gant. I've had the privilege of getting to know him and having many conversations with him. And I think produced along with our response briefs are multiple emails from Investigator Grant. So for example, in one of our conversations, I asked, whether the decedent, Mr. Shah, had a gun or weapon on him, whether he was the intended target, whether he was involved in a verbal or physical altercation, things of that nature. His response was, no, there's no evidence of that. And he says that statement appears accurate to me at this stage in my investigation. After we got the letter from the defendants, from Weinberg Willer, saying, hey, these discovery responses are incomplete or misleading or false, I called up Investigator Gant and I said, what the heck? I know that there's some information in the investigation file that they recently produced to us, but do you stand by these statements? And he said yes. And he said the stuff about the guns, among other stuff, was hearsay and it was pure speculation. And he's been receiving all different kinds of information from different avenues, and that he wasn't taking that into account because it didn't rise to the evidentiary value for his criminal investigation. And so I'm happy, that we're moving beyond sanctions, but I don't want the court to think that there's anything misleading here.
Let me ask you this though.
Yeah.
If some of the people providing the information are your plaintiffs, and they're providing, even if it doesn't rise to the level of a probable cause hearing, which some of it may have, some of it may have not. Y'all didn't produce the probable cause information. So I don't know what a court may have considered. I don't even know what stage the criminal case is in. But as I tell everybody who does civil, if you don't know everything about your plaintiffs, and if you don't have all of the information from your plaintiffs, and then further down the road, there's information that comes out that they're either saying something different, or there's evidence that there was something different than what they told you, that's a problem. And so you should know more about your plaintiffs in their case than anybody else should know. And it should never come out that the mother assumes that the daughter knew something about the brother's death that you all don't know. So this is the issue that I have. From your perspective, it looks very different. But from the perspective of the defendants, when all of this stuff comes out and you're starting to get contrary information, which seems to have been initiated by the person who is a named plaintiff, there's an issue. It could have been resolved by you all talking about it and saying, hey, this is what we're receiving from plaintiff. Let's talk about this because you all are saying that we're giving you information that's not correct. Well, discovery is not just responding on paper to what you receive on paper. You can call them up and say, hey, listen, y'all are alleging that we have some information that we don't have. Let me look into it, then we'll update our responses. I don't think any of that happened. I think it was, we're putting information out there, it's unverified. We have not verified the information. And so then all this other information comes out, and then we have to now decide whether the information in the complaint is what's correct or the information in these videos that we're getting from the police is what's correct. Y'all could have talked about this before it ever came to me.
Well, I completely agree.
Yeah.
Yeah, this is what I mean about being professionals in the practice of law. I don't have to like you. I'm not getting, it is not my case per se. I'm not the plaintiff in this case, but as the guardian of the plaintiff's interest, it works better for me to have a conversation instead of being adversarial. If you all had talked about this, we wouldn't be here discussing this. We wouldn't have another case filed in DeKalb. We wouldn't have, there's a lot of stuff that would have been streamlined in this case if you all had talked about this. And that's the purpose of the whole, let's talk about it in discovery. And then if we can't talk about it, let's get a letter out. But first, let's talk about it.
Understood.
Because I promise you, everything that is going to be produced at trial in this case, y'all going to know it prior to trial. So I don't know why we're playing hide the ball at this point.
Your Honor, if I may, just because you have the memory of an elephant and I have the companion case and you're going to remember. So I knew nothing about these sanctions hearings. We represent the companion case, another decedent, and we did our own independent investigation. The first thing that we did was we subpoenaed the records. So we had those and we knew everything that was in the file. Second thing we did was we went out and looked for people and talked to them. And that's how we got the affidavit of Jamaica Tuggle. Not only did she provide an affidavit, she provided a video, Your Honor, of the sister of the person that the decedents were visiting, who is saying on the video, he was just here playing with my kids. He was just here playing with my kids. So this is not an issue of an affidavit versus an affidavit. This is independent evidence taken at the time she filmed them dying that shows that they were on the property and they were invited. And I'm only interjecting that because I think that you do have a negative opinion of the plaintiff's case. And I want to make sure that you have other evidence.
Please don't ever assume because I'm fussing at somebody that my opinion has changed, because what you will always get from me is fair and unbiased.
And I believe that,
I will tell you what I see and why I believe there's a discussion being had and why I'm having to have a hearing. Now, I'm going to pick that apart all day, every day. And there will be times in motions hearing where you will think, oh my gosh, she's just not understanding anything I'm saying. She's asking all these questions. And then when my written order comes out, you will understand that I understand exactly what's going on. But the whole point is I've had to take the long way around to let you all agree that y'all could have had a conversation about this and we wouldn't be in this posture. So no, I'm not holding grudges or I'm not having a bias against anyone. I don't do that because, as I said, I'm here to call the balls and strikes to make sure you have a good trial, a good, clean trial, that both parties get to a trial if that is what works for you, or that you get to the settlement posture if that's what works. I don't hold grudges. I could have done this job for as long as I have holding a grudge. But what I will say is I want people to be professionals and don't get so stuck in your adversarial position that you're not willing to exchange information, whether through a formal discovery process or informally by picking up the doggone phone.
Yes, Your Honor.
We're happy to supplement.
You don't have to prove how upfront you are, Ms. Farley. I don't care. Y'all just don't understand. I like trials. I like civil practice because it is an exercise for my brain. I'm not taking sides on one side or the other. I'm going to make the decision that the law directs me to make. Never going to be able to say that Judge Hayward is unfair or she didn't listen to my side. I'm always going to listen. But if I see that y'all could do it better, I'm going to tell you, talk to each other.
Yeah. Your Honor, you're highly regarded, and that was not the allegation I was making. I was just making sure that you do. I think there was a perception of, hey, there's some shadiness going on with respect to these questions. And I just wanted to point out that there's evidence. So with that, Your Honor.
I see why they would have brought a sanctions motion. I didn't say I thought it was shady. I see why they would have gone that route. That's what I said. Okay. So let's be clear. My ability to see it from both sides. So what I'm saying to you is everything you need is going to come out in discovery. Whether that's admissible at trial is a different decision, but a lot of stuff is going to come out in discovery. Deal with it. And then when your case is in the posture for trial, I will give you a trial. We clear?
Yes, Your Honor.
Thank you, Your Honor. And since this is now taken down and on the record, the last thing I want to put on the record, because I've said it, I put it in the briefs. I've worked with Brian Mickelson and Michael Smith and all these lawyers. I've worked well with them many times. I haven't even had a motion to compel, I think, in 10 years. I hate fighting over discovery. That's the way I do it. So let me just tell you, for the record, nothing about what I've said has ever been to be putting it on the attorneys. My whole problem was you got a plaintiff telling the police something contradictory and it was never turned over to us. Our clients have a duty to tell us what the stuff is. And when you find out that that's not it, you have to tell them that the facts are the facts. They got to come out. That's all we wanted. So for the record, since it's being taken down, if this ever goes up or anything like that, I want it to be clear. Nothing about whatever I've said has been designed or meant to impugn anything on the attorneys involved. But I do think it's a problem when a party's not giving us stuff, and it's important because they're telling the police. So that's it. And that's all I wanted to say. So thank you, Judge.
Well, I just think that it's important for attorneys to remember that we're all professionals. We shouldn't take a personal view where we're like locked in our views without discussing what's going on. Because even though there's a formal discovery process, information exchange in an informal setting sometimes gives you both the opportunity to have a better posture with the case. Okay? We're clear?
Clear, Your Honor.
Thank you, Your Honor.
Your Honor.
So clean slate. Yes, ma'am, Ms. Richards, I'm sorry. I got progressive, so it's hard as heck to see these words. Go ahead.
Completely understand. Before we get off, is it okay if I get orders from the attorneys that would like transcripts as well as their addresses, contact information in our chat?
You all send Ms. Richards the information necessary if you're going to participate in takedown, or if you need copies, go ahead and chat that to her. Ms. Richards, you stay on as long as you need to collect all of that information. But at this time, the court has heard. I have decided I'm going to issue an order about the 7 days for the discovery responses. I'll issue an order with respect to the sanctions. And I'm going to tell you at this time, I don't believe that sanctions are appropriate since we've had this discussion and I now know where the parties are. But I'm not saying that won't be reconsidered if it's necessary. Okay.
Thank you, Your Honor.
Thank you.
All right. Thank you. Free to go.
Thank you.
All right. So Mr. Jeff Morley has been on here a minute. Mr. Morley, I have in no way meant to leave you out there hanging, but I know I have a couple of cases where we had individuals who weren't here when they were called due to technical reasons. And we also had individuals who may have come in later. Now, Ms. Doe, and
courtroom.
I'm sorry.
Can we close the courtroom? Excuse the deputy and close the courtroom.
Yes, I'm sorry, deputy. Thank you so much. We're down. All right. So, Mr. Morley, which case are you? Oh, where'd he go? There you go. Mr. Morley, unmute for me. Because I've been looking for your case. I can't find it. Can you unmute?
Mr. Morley is attached to the case you just heard, Judge. He was the private investigator or note taker.
Okay. You're free to go at this time, Mr. Morley. Thank you. Take care. All righty. So, okay. So I feel better now because I kept thinking I should be able to find him. All right. So the next All right, so Willie Bell versus Yvonne Williams. I know that those parties are still here, and also Miss Doe and Attorney Baker. Now, Miss. All right, so I have found the answer of Miss Doe, and she is correct. She did file her answer electronically. It was e-filed on September 6th of 2024, which means that she has the case. I'll send an order rescinding my default judgment in this case, because Ms. Doe has not only answered, but has answered in a way that shows that she believes that she has not breached the contract, because she has not been a party to a contract with Midland Credit or First Electronic Bank. So,
Judge, just to be clear for the record, we did not issue liability. I think there's a miscategorization in the system. We only issued a rule nisi. The system says judgment as to liability in rule nisi, but we only issued a rule nisi stating that that this judgment was requested and that the defendant responded and calling both parties forth.
Yeah, because I have the rule nisi that we entered, and it says rule nisi parentheses, no judgment as to liability.
Yes, ma'am.
Oh boy. Okay, yeah. E-filing is its own interesting thing. So Miss Baker, Miss Doe, you all have the opportunity to conduct discovery in this case. If you wish to do that, you're both entitled to that. Miss Doe, that means that they can request information from you regarding your answer and your belief that you have no, you're not in what they call privity of contract with the parties, the plaintiffs. And also you have the opportunity to request from them discovery so that they can prove what it is they're alleging in their complaint, okay?
Okay.
All right. So at this time, this case is going to be taken off the hearing calendar. Then the court is going to grant you the opportunity to conduct discovery. And once the discovery period is over, then you, if you all have not resolved the case at that time, then it can be put back on the calendar.
Okay.
All right. Thank you, Ms. Doe. I'm glad you appeared and we were able to work this out. We don't, things get filed, but sometimes when they're filed, they have categories for what they should be under. And this happened the other day. Somebody filed a motion. It wasn't in a motions category. So it took us forever to find it, but we found it. So we'll go ahead and you guys reset for discovery. Ms. Baker, do you have information that you wish to give Ms. Doe as to how to contact your firm?
Yes, Your Honor, I can provide her a phone number.
Okay. So Ms. Doe, I do say this to discovery. If you're going to conduct what is called discovery, you do it in writing and you file it with the clerk's office and give a copy to the other side. All right. So whatever information is in the clerk's system, then you can respond to them in writing and on that information. But also Ms. Baker has a phone number that she'll provide to you. Ms. Baker, can you chat that to her? Ms. Doe, you'll see a red box with a white number inside it. If you click on that, then that should give you the information that you need.
Okay, I have it. Thank you.
All right.
Thank you, Your Honor. May I be excused?
Yes, ma'am. Thank you for your patience.
Thank you.
All righty. And thank you, Mr. Henshaw and Mr. Kane and Ms. Williams for your patience, because we are now at your case. Mr. Kane, is it Kane or Bell?
It's Mr. Bell.
Okay, because I have Willie Kane on the screen.
That's Willie. It's Willie Bell. I think he's not technically gifted, and he's not been able to change his name, but that is my client.
I got it.
So, Your Honor, this is a hearing on damages as to the default with Miss Williams. I think I see that she is here. I would like to just
Ms. Williams, will you let me see you, please? There you are. I see it. Well, I see them all, but I do see something. So, Ms. Williams, as I stated, you didn't respond to the lawsuit, but you can give information with respect to the damages as they are stated in this case. So what's going to happen is Mr. Bell, Mr. Henshaw, on behalf of Mr. Bell, will present damages in this case, and he'll explain what he's asking for from the court. You will have the opportunity, if you have any information that changes the amount of the damages, or if you've paid on the damages, you can present that so that the court can consider it, okay? All right,
Yes,
so Mr. Henshaw, but Mr. Bell, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Mr. Henshaw, your witness.
thank you. Mr. Bell, could you tell the court just a little bit about yourself and your background, please?
Yes, my name is Willie Lee Bell, and I'm from Atlanta, Georgia.
Thank you, sir. And where do you reside?
I stay in Atlanta, sir.
Okay. Where were you on October 9th, 2022?
I was at Washington Park, sir. A park where everybody go and have cookouts at, sir.
And why were you there?
Well, I was there at a cookout, sir, at a friend of mine having a big cookout there, and I was there to celebrate.
Is that the one off of MLK?
Yeah, yes, ma'am. Washington Park.
All right, I'm trying to orient myself, so I know where that is. Okay, go ahead.
And what were you doing when this incident with Miss Williams occurred?
Well, I was sitting on my bike in a parking lot, in this parking lot, sitting on my bike when Miss Williams had came in the parking lot. She had her music on.
All right,
loud.
Ms. Williams, you've lost the opportunity to challenge the factual statements because you did not answer. Okay, when you were served with process, it gives you a form that's called a summons that tells you exactly what you need to do if you want to preserve your ability to respond. So I'm going to ask you to stay quiet because you've given up your opportunity to respond. All right. At the time when we start talking about damages, I will give you the opportunity to give me any information you have regarding damages. But for right now, Mr. Bell gets to tell me whatever he wants to tell me because you've lost the opportunity because you didn't answer. People get stuff in the from a court, and instead of operating legally, if you don't understand what it says, take it to a lawyer or have somebody explain it to you so that you don't miss opportunities. People don't have the time, folk don't read it. I spend more time on these types of hearings where people didn't even read the information. So you've lost that opportunity. Be patient, and then I'll let you talk about damages. Go ahead, Mr. Henshaw.
Thank you,
And
Your
Honor. One thing, Mr. Bell, when you say on your bike, are we talking about a motorbike or a bicycle?
I had a motor scooter, Your Honor.
Like less than 30 cc's or less?
It's a 200cc motor scooter.
Oh, okay.
Yes, ma'am.
Okay.
Yep. Thank you. And Mr. Bell, can you explain what happened when Miss Williams' car collided with your bicycle or your bike? Sorry.
Yes, sir. I was sitting on my bike at the park, and Miss Williams, she came in the parking lot, and instead of she looking back saying that was I behind her, she didn't look back because she had her music on and she backed into me, and other people had to let her know that she had hit me. And when she jumped out the car and seen me on the ground, she was panicking. She was panicking because of what happened. And I'm on the ground, my bike is on top of my bike had don't when she bagged in, my bike had don't fell on top because I fell to the ground, my bike had fell on top of me. So when I got up and got to myself and tried to lift my bike up, she gave me her tag number and gave me her phone number and said that her brother was gonna fix my bike. I guess she thought I wasn't gonna go to the hospital the same day, but I went to the hospital and they did x-rays. And the next day, I went back again and come to find out I had to go to a back specialist. So when I was at the hospital, I called Miss Williams and let her know that I was at the hospital and I was hurt. And what she did is hung up the phone and I didn't hear from her no more, you know.
What injuries did you sustain as a result of the accident?
Well, I suffer from a back injury and my neck injury, and they had to send me to a back specialist to do some x-rays, and I had to do an MRI and go through therapy, but I couldn't really afford my therapy, so I had to keep going to the hospital, you know. And when they found out that I had on my back was messed up, they want to do surgery, but then they started giving me, they said like before they do surgery, they want to give me a lethal injection. They want to try the lethal injection is a thermin and see what that help before they go to the surgery. Because the age I am, I'm 58 years old, so I've been doing lethal injection for the time that I got hurt, and I'm still going back and forth getting lethal injection.
How many injections do you think that you've undergone at this point since 2022?
At this point, I don't did 3 injection shots. Right now, my next injection shot is on January 27th. And after that, they're gonna if that don't do no good. They got me on these heavy pain pills that keep me drowsy and sleeping all day. So they saying if the injection shot don't do no good, then I might have to go through surgery. And that's something that I don't want to do because the age I am today. But if I had to go through it, I will go through it because right now they saying that, you know, like if I don't go through it, then it's gonna get worse before it get better.
What other treatments, if any, have you had?
Well, like I said, they put me on a program where I went to therapy. I did therapy for I did 9 sections of therapy. And then my Medicaid could not pay for the rest of the therapy, so I had to drop the therapy and kept going back and forth to the hospital. And the hospitals I was going to, I couldn't afford that, so I had to go back to Greater Hospital where I had to let my Medicaid take over from now. You know, I'm on Medicaid because I'm on disability, and I had to let my Medicaid pay for the doctors and what I was going through and stuff like that. But I'm still going back and forth to doctors now. I'm still going. They still got me on the counter. Like I said, I have on the January 27th, I go back for another shot in my back. And after that, they said if that don't do no good, then my next step is going to surgery.
All right. And sir, at this time, what all clinics have you been to for your treatment?
Well, sir, I've been going back and forth to clinic since this accident happened. My first clinic when it first started, I was going to the clinic on P Street. I forget, it was AC something like that. That was a back specialist place where they was taking me back and forth, you know, trying to see what was going on with my back. And when I couldn't afford it, I had to go back to Greater because my Medicaid, when I accept, they didn't want to pay for me going back and forth to the expensive hospital. So I had to go back to Greater Hospital to continue my physical and everything. I had to go back down and continue on taking the shots and everything because the hospital I was going through, my bill was up. My bill was up and I couldn't afford it, sir, because I was on Medicaid. So I had to go back to Greater Hospital to continue. And that's why I've been going back and forth since then.
All right. And was the place that you went to, was it called AICA?
Yes, that's it, sir. It was AICA. Yes, sir. That was the place. It's on P Street.
And have you treated with Grady also?
Yes, sir. I was with Grady, but when I left ACRA, I had to go back to Grady because I was in so much pain and they had stopped treating me at ACRA. So I had to go to Grady and continue my treatment. And that's where I've been at since then, sir, from the last couple of, last 2 or 3 years going back and forth to Grady's, and I'm continuing on going now.
Thank you. And sir, I'm going to share my screen with you for a minute. Sir, are you able to see my screen?
Well, sir, I can see it a little bit, sir, because I have glaucoma in one of my eyes, sir, and I can see it a little bit. I can't see that far because everything is kind of blurry, sir.
Sir, is this an accurate list of the medical expenses that you've incurred since being involved in this incident with Miss Williams?
Okay, I'm zooming in. Yes, this is this is it, sir.
And that total $32,410.03?
Yes, sir.
Okay. And is that consist of your treatment with Grady from October of 2022 to January 8th of 2024, and your treatment with AICA Orthopedics from 10/12/2022 to December 1st, 2022?
Yes, sir.
Okay. And you're still in treatment at this time?
Yes, sir. I'm still at greater treatment, sir, because they're thinking about doing surgery. And like I said, at the age I am now, I really don't want to go through it. But if I had to go through it, I will. But they're going to give me another shot in my back on the 27th. And if that don't help, then I ain't gonna have no choice but to go through surgery, sir. And that's something that I don't want to do, but to stop this pain for what I'm going through, so I don't have no choice.
Sure. And Your Honor, at this time, I'd like to move the list of special damages into evidence as Exhibit 1.
All right, they will be admitted without objection.
Thank you.
All right, continue.
Just a few more things. Mr. Bell, at this time, do you still, how has this pain impacted your ability to perform your daily activities?
Well, sir, I used to do part-time work, sir, but now I can't do part-time work because of the injury in my back. I can't bend down because when I bend down, I have a straight pain coming up towards my back. So I had to stop doing part-time work to stay at home. So I usually walk in the park. I can't do no walking now because I got a limp in my leg where the straight pain come down. When I walk on my right leg, it's a straight pain come down my leg, sir. I have a cane, sir.
How has this incident changed how you feel about your safety or your independence?
Well, sir, like I can't do the things that I want to do now, sir, because of this injury. I can't walk. I cannot walk my dog because, the pain that I be in now, sir. So I'm at a point now where I'm at a standstill, sir. Just the far as I do now, sir, just go back and forth to my appointment and make sure that I'm getting treated and ask the doctor, is it another way to try to keep me from going into surgery? So, like I said, after January the 27th, sir, after I take this last shot, if that don't do no good, sir, then I'm gonna have to go into surgery.
Mm-hmm. And sir, have you had to rely on any other people since this incident?
Yes,
to
sir.
help you? What has
Yes,
that
sir.
been like for you?
Well, it's a bit like I felt like I was helpless, sir, because I'm used to doing things on my own because I'm a very independent person. But when you had to ask somebody to help you, call one of the family members to help you while you're going through this, you know, it's a really bad feeling, sir, because I'm used to doing things on myself. I can't really cook the way I want to cook because of the pain that I have in my back. And there's a certain way I get outside, get out of bed in the morning. I can't get up the way I normally get up. I had to get up sideways because if I get up the way I supposed to get up, a sharp pain go through my back, and I had to lay there until it died down a little bit for me to get back up again.
Right. And what is it you miss most about your life before the collision, sir?
Well, I miss walking, sir. I'm used to walking. I'm used to walking my dog. I have a park in front of my apartment where I stay at. It's a big old park where I'm used to walking my dog around the park. And lately, I haven't been doing that lately, sir, because of the pain and what I've been going through. So I felt like that I want to give up, sir, because the pain that I was going through, sir, I felt like I didn't want to live no more. And the pain that I was going through, sir, it was unbearable, but they keep giving me these shots. And these shots wear off in about 3.5 months, and I had to go right back and get another shot again. And it seems like the shots ain't lasting the way they supposed to be now. Is the pain don't got now, sir. When they give me a shot, it lasts now about 1 or 2 months, and I'm back in pain. So I had to call an ambulance to come and get me so they can take me to the emergency room and try to give me some kind of pain pills to stop this pain, sir.
All right. Is there anything else you want the judge to know about this incident, how it's affected your life?
Well, sir, it's affected my life a whole lot because I can't do the things that I want. I can't spend time with my daughter because I don't want my daughter to see me like this. So I try to isolate myself and stay on going back and forth to my doctor's appointment. Instead, I don't even go around family members like I used to no more, sir, because I feel like I'm helpless and I don't want to depend on them. I'm doing this by myself now. So, yes, it's how it affected my life, sir.
Okay. Your Honor, I'm going to share just a couple of Bill's exhibits here. Mr. Bell, do you see this document that I've shared with you?
Yes, sir. I'm zooming in.
Is this a true and accurate copy of the bills and the charges you've received from Grady Hospital?
Yes, sir.
Okay. I'm just going to scroll through these documents here. Your Honor, just for the sake of the record, there are some things here that are from 2019 that were pulled out, and they are not included in our summary on the list. But they are still part of this exhibit. I wanted to be fair to the defendant to give her some time to look it over, or if she has questions about it, I can, I'm happy to do so, whatever, but I just wanted to move the exhibit into evidence at this time.
Okay. All right, so there's some things that are going to be excluded from the court's consideration or included?
So there's an exhibit here. It's just a list of all of his things that are.
So he had some
he had some things that are unrelated. Yeah.
Okay, that's fine. We can redact those or just tell us which one of those are not going to be considered.
Yeah, all we did, Your Honor, is we went ahead on exhibit 1 and we just pulled out the charges that were post collision over at Grady.
Okay, thank you.
So the only amount we're asking for is the 22,844.28. But there's some other things on exhibit 2 that would exceed that amount. We just pulled those out. We're not asking the court for those.
Okay. So $22,804.28, and those are from Grady solely?
Yes.
All right, thank you.
All right. And then I also am going to share this bill. Mr. Bell, is this an accurate copy of the bill that you received from AICA?
Yes, sir. And they've been getting on me about that, sir. And I'm letting them know that I don't have the funds at this time. And They started sending letters every 2 or 3 months saying that I need to pay this and pay that, but I'm telling them that my first lawyer that sent me to this case, sent me to this hospital, he could not find a defendant because he said the defendant had moved and had got rid of the car that she hit me in. So he got off my case saying that he could not do nothing else for me. So that's when I had to get in touch, reach out to somebody else, another lawyer, to try to see could I find this defendant and bring this defendant to court. But like I said, it's been a while.
And sir, but this is an accurate copy of your bill from AICA totaling $9,565.75.
Yes, sir.
All right. And we would move that into evidence also as Exhibit 3, Your Honor.
Okay, $9,965.75.
$9,565.75.
565. Okay,
yes.
Thank you.
Thank you. And Mr. Bell, these are your records here from where you went to treatment at AICA?
Yes, sir. Them are all the records that I went.
All right. Your Honor, it's 113 pages here. We'd like to move it into evidence as Exhibit 4 at this time.
Okay, it will be admitted.
All right. That's all I have testimony-wise from Mr. Bell at this time. Your Honor, we are really just seeking damages, compensatory damages, medical expenses. There's no lost wages that we're claiming, but the total damages, special damages of $32,410.03. And then we feel that just a judgment of $150,000 in terms of compensatory damages would be sufficient, given that Mr. Bell has been in suffering since about a little over 2 years at this point.
And the $150,000 will be inclusive of medicals, pain and suffering, and any other anything else alleged in the complaint?
The total damages we would ask for would be $182,000. So it would be the medical expenses plus $150,000 total, or $75,000 per year, and then medical expenses of $32,410.03. So $182,410.03.
Okay. All right, Ms. Williams, unmute and tell me that if you have any objections to this, if there's anything that you paid or was paid to Mr. Bell to compensate him for the damages.
No, ma'am. Initially, only thing that was nothing was wrong with this man bike. I told him that I would have my brother come and look at the moped that he was on. Only thing that was wrong with it was the pieces was broken. I asked, did he want me to call the police the day of? He said no, he refused because he didn't want the police dealing with nothing because he had guns on him and all that extra stuff. So that's the only reason, that's why he got my information as far as the tag and all that. I did not get rid of my car. My car was repossessed.
Okay. Do you have any knowledge or information regarding the amounts that he stated for what he's asking the court to give him?
I really don't know.
Okay. All right. So at this time, the court will grant judgment in the amount of $182,410 plus cost of court.
All right. Thank you, Your Honor. Should I prepare the order?
Yes, please. Send it to Ms. Powell.
Thank you very much. I will do it. And do the exhibits need to be sent to Ms. Powell as well, just for the sake of the record?
Yes, please. Make sure that, no, don't send them to Ms. Powell. Just file them.
Okay.
With the court. If you've already filed them, that's fine.
All right. Thank you, Your Honor.
All right. Ms. Williams, if ever somebody appears at your house with paperwork and they're serving you, or you come home and there's paperwork at your house, please read it. please look at it. Please follow the instructions on the summons, because this on these Wednesday calendars, I can't tell you the number of people who get served with something. They never read it. Even if they read it and they don't understand it, they never follow up and ask anybody how best to approach it. Things mean something. If somebody takes the time to serve you with a lawsuit, then you have the right to defend yourself, but you have to do it in the way that the law allows. Okay? Don't just assume
I
it's
just
nothing.
haven't been having the time. It's been so much stuff going on with me. My dad been in and out of the hospital, and my brother just got killed last month. So it's been a lot of stuff going on. So I really haven't had time to be focused on something that I never did. He drove behind me. He was in the wrong. I just agreed to fix his freaking bike, and now I'm getting sued for something that he did in the wrong.
I got you, Ms. Williams. I'm just telling you, I am following the law. And so I'm just giving you the benefit of how this is how the law works. Okay. You'll get the information that the court has decided here today, and you'll get a copy of it. All right. All right. Thank you. The court is adjourned at this time.
Thank you, Your Honor.
Ms. Powell, hold on, stay on for me.
Excuse me, Your Honor.
Yes, ma'am.
I'm sorry. Yes, Mr. Bell.
Your Honor, before I get ready to go, Your Honor, I just want to say that when I was in the hospital and when I gave her,
okay, Mr. Bell, we've decided all that. You can talk to Mr. Henshaw about that, okay?
Yeah.
And God, you reap what you sow. You know you're wrong.
Don't get into it.